I don't think this is going to go away for the president.
Yeah.
I think the court went too far in the impeachment case. So in 1994, the Constitution became this document that people could invoke to pretend that we have these shared values. So my personal view is that the provinces should be abolished. 18 parties in the National Assembly is too many.
Spread the fire. Welcome back to SMWX. Today, I'm very excited to be joined by constitutional law expert extraordinaire, Pierre de Vos. Pierre, thank you for joining us on SMWX.
Oh, thank you for having me here.
What a time to be a constitutional lawyer.
It's very hard work at the moment.
Have you slept?
Yes, luckily I can sleep because I'm not personally involved.
Yeah.
It's very interesting, and it will be very interesting going forward because there are so many parts of the Constitution dealing with coalitions at national level that hasn't been tested. So there's new things are going to come up all the time.
So true. I see you've got your red overall on here. What is this a sign of your new?
Well, it was either this or the blue jersey, so I decided for the red rather.
No, it's really interesting, and you've played a key role in the interpretation of our Constitution and in really important academic work teaching the Constitution too. Where to from here now with this new coalition government? Can you give us a sense of what the constitutional expectations are now that we have a president elected?
So the president is elected and must be sworn in within 5 days of the election. So that will be Wednesday, I think. Then the president has to appoint a cabinet. In terms of the Constitution, the president has that power and complete discretion. Of course, it never works like that because even if there's the president has a majority of support from his own party in the National Assembly, they have to consult with the party and so on. Now it's going to be much more difficult because there's this coalition agreement, but it's a framework agreement. There's not really that much clarity about which of the coalition partners will get which portfolios and so on and so on. And there is no provision in the Constitution for how long, what the deadline is for the appointment of the cabinet. Once the president takes office, the previous cabinet stops being cabinet members. So there are no cabinet members for the period until the president appoints a new.
That's a good thing. Right?
Well, we notice some people will ask. But so the president is supposed to exercise all constitutional duties speedily and without delay. There's a provision in the Constitution like that.
Sure.
But there's no time frame. So if it takes long, it can, if it takes 3 or 4 weeks, then there will be 3 or 4 weeks where we have a president, but not a government in the sense that they are not cabinet ministers. So it will be interesting to see how quickly this is done.
That's really interesting. It's interesting that our Constitution, as you say, that gives a very tight deadline for the president, but virtually, not quite unlimited, but no specified deadline for the cabinet.
Yes, so the Constitution is actually, we discussed this earlier, is quite trustful of the president, emphasizes the president, and gives the president, once elected, this discretion to appoint the cabinet. The only limitation legally is that only 2 of the cabinet members can be from outside the National Assembly. So the Constitution also says that the president is the head of the state, which is the kind of role that the queen or the king now plays in another system, and the head of the executive. And once the cabinet is appointed, the president exercises the executive authority with the members of the cabinet. So once appointed, the cabinet the members of the cabinet becomes more powerful, I guess. But at the same time, at any time, for any reason, they can be fired by the president. And there was that crazy case where they were going to go to court to challenge the removal of Pravin Gordhan.
Oh, yes.
But that case could never have gone any further because this is such a political decision. It's not something a court can review because these are political decisions. And in this case, it will be reached by the president with the parties that are going to be in the coalition.
There's a deeper constitutional debate, which I think was raised by then Deputy Chief Justice Moseneke on the powers of the president and how extensive they are. What do you make of that view?
I'm very conflicted or ambivalent about which one of the systems work better.
Yeah.
The problem is that politics is about who decides and who decides who decides and who decides who decides who decides. Somebody has to have the power, say, to appoint the head of the prosecuting authority, the head of the defense force, whatever.
Yeah.
Somebody has to have the power to decide who's in the cabinet. So in that sense, it is not clear that if you give less power to the president and to some other person or body, that will actually be better. So, you know, whether the president appoints the public protector or the head of the commissioners for the Human Rights Commission, or whether the parliament, it might make a huge difference, but it really depends on the context. So, yes. So, in principle, I think our president in our system has a lot of power, have a lot of discretion to exercise, to make decisions separate also from the cabinet. But maybe because of the system we have, that the president also has to retain the confidence of the parliament, of the National Assembly. So he must make sure that they don't have a vote of no confidence in him. It's a kind of check that might, well, in some contexts will be very powerful because it's when the president is not in full control of his own party, when they have a majority, or where there's a coalition, and the coalition and the parties in the coalition that is not the largest from the largest party have some common cause with people in opposition, which at the moment is not the case. But if that had been the case, the president's position would have been extremely precarious.
Yeah. Thanks for watching SMWX. Before we get back to the episode, I just wanted to let you know the 4 ways that you can help support this channel if you want to see us growing bigger and better to keep you more entertained and informed. The first way is you can invite me to speak at your company, your school, your institution. You'll see the contact details down below. The second way is that you can become a member of this channel. Become a member, or you can give us a thanks. You'll see there's like a heart with a $sign in the ribbon below this video. Buy me and the team some coffee for this episode. The third way you can get involved is you can advertise on the channel. Now, I'd much rather the community of viewers would be advertisers on this channel than me going out to people who don't really know about SMWX and trying to explain it to them. So if you're a viewer and you have a business and you want to partner and you love this platform, let's partner on this channel. And then finally, you can buy merchandise, you can buy books. All this is in the description down below. Now let's get back to the episode. Yeah, and I suppose there are some things that we're going to learn about the Constitution that we didn't know before, and also this interplay between political dynamics on the one hand and the constitutional text and our particular context versus our particular constitution, and how those will maybe come together in a new way now.
Yes, so what people don't always consider is that in most countries with a constitutional history of some sort, there are the written things written down in the constitution or in legislation, and then there are the kind of soft law, the conventions. You know, for example, in some countries, it's not written in any constitutional law, but there's a convention that the party with the most votes will get the first opportunity to try and form a coalition government if there's a coalition. We have fewer of those conventions because we have had one party dominating since the end of apartheid or the alleged end of apartheid. So so this is, of course, the maybe, and this would be a hope as a constitutional scholar, because it is more than one party in the government, and because maybe they're not going to trust each other that much.
Yeah.
It might help to formalize these kind of rules that might become a convention.
Absolutely.
Because then they help us to work the system. At the moment, so many things are not clear. One example would be the cabinet the cabinet are collectively accountable for the decisions of the cabinet. The members of the cabinet exercise executive authority with the president, but we don't know which decisions has to be taken by the whole cabinet or which decisions can be taken by the minister. It is completely unclear. There's one case about it where the court said a minister who issues regulations, whatever, or issues directives has to have it approved by the whole cabinet. But we actually don't know. We know that to table a draft bill, the cabinet has to agree on it.
Right.
But many of the less serious kind of decisions, we don't know actually whether it is legally or by convention required for the cabinet to deal with it. My impression is that after the Mbeki era, the cabinet actually decides fewer things, and cabinet ministers have had more discretion to make decisions without getting consensus from the whole cabinet. So that is something that I'm going to look out for as we go forward. Definitely.
Very, very, maybe the question of the next 5 years, because I'm sure there'll be an initial period of jostling within cabinet to see how much ministers can do and how much they can't do. And if that's an area of ambiguity, hopefully it'll be cleared up fairly quickly.
Yeah.
I'm also just thinking when you talk about draft bills, that even that is fascinating, because even if the ANC, for example, wants to do something legislatively new, and we know there are lots of areas, I think of land reform, I think of, any number of controversial issues. If they want to do something serious legislatively, that's going to have to at least come through cabinet at some point.
Yes. So the interesting thing here, of course, is that I think it will also accentuate the separation of powers, which we don't necessarily think about that much, because the same party has always controlled since 94 the two branches. So to get something through the cabinet, according to this agreement, there has to be sufficient consensus, which means the DA and the ANC would have to agree. So it will be actually very difficult to get through the cabinet either the DA's pet projects or new initiatives from the ANC. But as we speak now here, I'm suddenly thinking, of course, that the cabinet has to approve the bill. The bill is then tabled in Parliament before the relevant portfolio committee. They can make any changes they want to the bill. So arguably, they can agree to a bill and say, we'll fix this when it gets to the National Assembly, because there we will get the other party. Say the ANC wants to do something a little bit more progressive. DA is against it. They agree to the DA version. They take it to the portfolio committee, and the majority of members of the portfolio committee are going to be from the other party. So the agreement will also, we will have to see what the agreement then says. Does it say anything about whether the members of the coalition who are members of the National Assembly, do they have to support the legislation? What is the role of the members of the National Assembly versus the role of the cabinet ministers in the cabinet? So
absolutely. And then presidential assent as well. Obviously, that's within the purview of the president in text, but I'm sure there'll be political conversations behind the scenes as to whether the president should or shouldn't give final say to whatever legislation is within his ability to sign off on.
Yes. So obviously once the parliament, the two houses have passed legislation, the president has to sign. He doesn't actually have a discretion to refuse to sign, although it has happened, but it's not actually allowed. He can refer it back for constitutional questions only.
Sure.
So, or refer it
Directly to the court.
to the constitutional court.
Yeah.
But he cannot say, I think this is really a terrible piece of legislation. I'm refusing to sign it. Yes. So that is a limited power, but it is there.
He might leave things on his desk for a very long time.
Yes. So this is what has happened in the past. The president and President Ramaphosa has been particularly notorious for taking his time and they're not signing it because there are people who are complaining. There are lobby groups that's lobbying him, and then it's not signed. Strictly speaking, in terms of the constitution, he can't just delay signing.
As you're talking as well, I'm starting to think about Parliament and the National Assembly specifically, and how Chapter 4 of the Constitution in some ways has not been able to really see its day in the sun because of ANC dominance, and how Parliament became a rubber stamping venue for executive decision making. We may, in one hopeful scenario, really see Parliament becoming the important institution it has always meant to be in this new, less one-party dominant situation.
Yes, so that is more likely to happen if the coalition agreement does not fetter the members of the parties involved in it in the National Assembly.
Sure.
But now what is going to happen, every single portfolio committee doesn't have a majority from one party.
Yeah.
The first thing they have to do when they meet for the first day, well, before that, we have to decide exactly on the composition, and it needs to be proportional to the parties, but the parties, whether you have one or two members on the committee, it's marginal. There's no formula. The speaker and the rules committee, which is loaded with people from the majority party, and Rules of Parliament speaks about the majority party, not the largest party, they will decide this. Then the committee sits, then they have to elect a chairperson. The chairperson of portfolio committees are quite important because they elect themselves. So each of the committees is going to have to elect a chairperson. If there is no deal between the coalition parties on this, each of those elections are going to become a mini contestation between the parties represented there. So, but on the other hand, after that, if there is not a very strict constraints on the MPs in the majority in the coalition, it will make it much easier, and it will hopefully enhance the kind of accountability. You can imagine a DA minister comes to the portfolio committee, and the ANC MPs are going to be much more rigorous in their questioning than they would have been if it's the ANC. And so, yes, it is going to be very interesting to see how that pans out. But on paper, at least, it's going to be much more robust.
I was just thinking to myself on this that if that formula is followed, then the ANC itself would be in the minority for the first time, not just in Parliament, but in all these committees.
Yes.
I knew it, theoretically, but to actually think every committee, the ANC will be in the minority. I think committees in the last Parliament, they decided had about 11 members. And so if we followed that, the ANC would have between 4 and 5 of 11 in all committees. That's really quite a change.
Yes, so it is. And I think people see things that committees do on television, like Thabo Bester, that was kind of the high point of the National Assembly because they actually really did the job. But a lot of the work are less high profile. When a bill is tabled, they go through the whole bill clause by clause. They all of those things. The ANC, in the end, it was in their gift to decide: are we going to listen to the opposition or not? Now, if the parties can find each other in the committee, across party lines, you can find changes being made that that might not have previously been possible. So this is going to be interesting.
Very.
Because those things depend on the personal relationships between committee members also. So for the people who are going to be in the opposition, it's going to be complicated. They have to decide in some way, are we going to be confrontational in that very personal way? And then we might not be able to influence what happens in the committees as much as otherwise would, or maybe it's not in their political interest to do that. And
What do you make of this framework coalition agreement that we have, and particularly the decision-making clauses about consensus and sufficient consensus?
I was a bit surprised by this because it really binds the two large, the ANC and the DA, into the coalition in a very fundamental way. Because sufficient consensus is defined, and in essence, at the heart of it is both parties have to agree before a decision of the cabinet can be taken, before there is sufficient consensus. This means both that the two parties in a way will have a veto on proposals from the other party that must be decided by the cabinet. But it also then means that it is much more difficult for those parties to wash their hands from a cabinet decision. So it really makes both responsible for, in a very fundamental way, that politically might be difficult to negotiate. Yes, so cabinet ministers are supposed to be collectively accountable. So once the decision is taken, they're supposed not to criticize it. Maybe, I don't know if that will happen. But in this case, it will be quite difficult not to criticize it from the two largest parties, because they have both parties have now, we know from this agreement, if it comes off, they would both have agreed to the decision. So
it's quite a bold, it's actually bold from both of them, because the DA would be worried that, there's a lot to fix and it might not be easy to fix quickly. And similarly, the ANC is also going to be worried that the DA, there's this idea that the DA will somehow govern from the minority. And so there are risks for both of them, actually, to some extent.
Yes, political risks.
Not that it's your field.
As a citizen, I'm going to be interested to see how this plays out. This is the wonder of democracy. These parties have made this decision. It might be catastrophic for them with the voters, and then that's democracy. It might enhance their standing, and that's also democracy. It's going to be interesting, though, to see whether the spirit of that provision, whether they can actually execute it. Can they really? Are they capable, personality-wise, and so on, to try and find consensus?
Yes, and also, decisive government is going to be crucial in the next phase, and it would seem that this will constrain. If there is a criticism of President Ramaphosa, it's that he takes consultation to all new levels. And he will now not only have to consult within his party, but try and find consensus within the cabinet. On the other hand, maybe there's more common ground between some of him and his co-partners than even in his party.
Yes, let me not comment on that last point. It depends, of course, coming back to the point I made earlier, which kind of decisions are going to be subject to this rule? Which one of the decisions would they agree requires cabinet approval, or can the minister initiate things on their own? Day-to-day running of a department can be done without getting cabinet approval, so it wouldn't be an issue. What it does suggest to me is that it is an option for stability, for little change in the policy area, because it's going to be difficult. The policy decisions, legislation, they will have to agree. It might be, the Employment Equity Act and the BE legislation is not going to change. But they're also not going to adopt new legislation on the ANC's preferred priorities.
That's a really interesting insight that emerges in that what we already have is probably not going to be tampered with, but anything new is also going to be very hard to do.
Yes, unless they somehow find each other and realize that they're not that far apart when it comes to economic policy or whatever the case might be.
Sure. Okay, let me steer you back into constitutional waters before we go to political and just ask, taking a step back from sorry. I have to go to Phala Phala first. Then I'll go to the deep jurisprudential questions. We've seen that the EFF has been very keen to reintroduce Phala Phala. This is also a question about the National Assembly. Their Constitutional Court application, as I understand it, is questioning whether the National Assembly fulfilled its functions of oversight by dismissing the Ngobo report recommendations. What do you make of this case from a constitutional perspective, and what are the constitutional levers in terms of reintroducing a report like this that has already been voted on?
So the second question, I think I'll take easier.
Sure.
I very much doubt that it is possible to reintroduce the report because the rules of the National Assembly, which was amended after the Constitutional Court judgment said they had to change it, has this process for impeachment. Right. First you do this, then you get the independent panel, then there is a further scrutiny. That parliament doesn't exist anymore, and everything that it's now, and that report is a report that's there politically helpful for people who want to criticize the president. But that report cannot now be used to start a new process in terms of the rules, because the rules say the process requires the appointment of an independent panel, and they cannot just dust off the old report. What they can do is, maybe second, it's also probably procedurally not possible to table a motion of impeachment against somebody who has not yet been elected because they tabled it before the election. But that doesn't mean that once the parliament starts going, they cannot use the rules of parliament to introduce a new motion for impeachment of the president, based on whatever factual claims that there was a serious violation of the constitution or the law or serious misconduct. So it can include Phala Phala and something else. I don't think this is going to go away for the president. Ultimately, as the Constitutional Court made clear in the EFF judgment, though, the first part of the process is a factual, fact-finding process. When it goes to the National Assembly, it's a political decision. So the MPs can say, well, we think the president did terrible things here, but politically we decide we're not going to impeach. And it would be very difficult to persuade a court to review such a decision by the democratically elected National Assembly. Of course, the parties who support it will have to understand that it might have consequences for them at the ballot box.
So it's interesting to me, just the procedural question, to the extent that you're saying that the impeachment procedure is, quite apart from like the transition from one parliament to another, is sequential. And so one step has to follow another.
Yes.
So it would be hard to go back to the previous step once one of the steps has already been concluded, i.e. the vote. So going back to the reintroducing your report.
Yes, so this is a consequence from this very complicated rule that was necessitated by the Constitutional Court judgment. So, and it's clear. It clearly says this is what happens first. Once this has happened, then this is the next step, and then this is the next step. So, previously, before the Constitutional Court judgment and the changing in the rules, you could table impeachment motion, as the DA and maybe the EFF, can't remember, did with former President Zuma at any time, and you can say there was a serious violation of the constitution or the law, and then the ANC at that stage would say, no, there wasn't. and that's the end of the matter,
Yeah.
which is why the rules now say, no, let's first have a process to check factually whether there is a case to answer. Then we decide to go forward.
Yeah. So this is so interesting to me. What is the status of the Ngcobo report? Do you think it could be defunct because it was in the last parliament, or could a parliament still rely on a factual report, even if it? Yeah.
Yes, I think it's complicated in the sense that the report is there. It can be relied on, of course, in the way that any other fact-finding, factual findings by anybody can be relied on. It cannot be relied on, in my opinion, at least, to say we don't now, when we start a new impeachment, we don't now have to have another independent panel, because the rules of the National Assembly says you have to have. And so in that sense, I don't think it has, in the context of impeachment in Parliament, it has no legal effect.
Very interesting.
Which is probably why the president's lawyers told him he doesn't have to pursue the view of the report.
Yeah, and also,
I don't know what the advice was, but I would assume that.
Yeah. No, that's quite fascinating. Just finally on this, because I think it's going to be a big legal question in the next 3 or 4 months, particularly if and when that case comes to the Concourt. My reading of the Nkandla secret ballot and impeachment judgments is not very fresh. But one thing I seem to remember is that the Constitutional Court was prepared to go quite far in saying to the National Assembly that they had a serious accountability function. So I think it's going to be interesting. On the one hand, there's going to be this argument that it's a democratically elected parliament, as you say, and what it decides is what it decides, and like it or lump it, basically. While you have some jurisprudence that seems to say the National Assembly actually has to do something more than just formally recognize accountability. It has to be substantive accountability.
Yes, so there are a line of cases, the secret ballot case and the impeachment case, the most prominent, where the court really went to town, so to speak, in hammering this idea that the National Assembly should hold the president and the executive accountable, that part of this, two of the most effective and most drastic measures are either vote of no confidence or impeachment. I think the court went too far in the impeachment case because it said, well, you can't have a proper impeachment without the rules. And then they told the National Assembly that once you have these rules, then you have to do what is necessary. So coming close to ordering it to have an impeachment process. I think that's wrong. But it is precedent now, so they can do it again. I think the principle behind it, though, is not wrong. And that is that the duty of the National Assembly to hold the executive accountable is not just, it cannot just be window dressing. There's always politics. They all, parties are going to protect their own, usually for worse.
And opposition parties.
And they will go even if there's nothing to impeach the president for. But the difficulty with this is, and the court's judgments, those cases, what the court is trying to impose a legal kind of framework on a political body. So it is very difficult to enforce the kind of obligation. So in the secret ballot case, for example, the Constitutional Court said, well, MPs, when they have to choose between loyalty to their party or their conscience and upholding the Constitution, they must choose the latter. And because they're going to face problems with their party, they can then vote in a vote of no confidence secretly. I think this is excellent. Practically, how do you enforce that? Those MPs are there because they're on the party list. If the party finds out they have gone against their leader, they might find themselves expelled from the party, or at the next election at number 400 on the 200 out of 400 on the list.
Yeah. It's going to be a fascinating moment for these tensions. And let's just go deeper into the Constitution as well, because it's been invoked in a series of fascinating and maybe frightening ways in this election. And it seems to me that on the one hand, the coalition government has put the Constitution, they've invoked the Constitution as a kind of precondition. I'm not sure exactly what it means, but the Constitution still has a certain political cachet which can be invoked to bring unity between parties. But on the other hand, it seems to me that constitutional reform, to put it mildly, has also been very much on the table from lots of perspectives. Patriotic Alliance, which apparently is part of this constitutional pact, says they want to suspend it. MK Party basically says, let's start from scratch in many ways. I would venture that the DA as well, in its stance on the equality clause, may be veering into unconstitutionality.
Yeah.
So I wonder, as a constitutional scholar, what you make of the way that the Constitution has figured in this election.
So this is really interesting for me. I think one has to understand the Constitution on two different levels. Normally, when a country and its constitutional system is normally premised on a minimum set of shared values in the society. South Africa doesn't have that. So in 1994, the Constitution became this document that people could invoke to pretend that we have these shared values. And then it stops the argument. It's the beauty of constitutions and law. You just say, well, the Constitution says so, we don't have to argue about it. And so the more that Rainbow Nation kind of consensus supposedly shattered, the more people critiqued the Constitution as an idea of a beautiful transition, as the idea of a shared set of basic values and all those things. So there's that. I think the MK Party's view on the Constitution is that. So it's actually, though, practically very difficult to change the Constitution. 2/3 majority. But the founding values in Section 1, which include democracy, supremacy of the Constitution, and the rule of law, requires 75% support in the National Assembly. So the kind of changes that MK are suggesting, that we should just abolish the Constitution or the supremacy of the Constitution, practically for the moment is not going to be possible. But of course, the Constitution can be changed, and if it doesn't work, it should be changed. And so what I will look for is, when people make arguments about changing the Constitution or not, are they not maybe arguing about other things?
Sure.
Are they arguing about policy or political questions or identity or whatever that's not only or primarily about the things that they are complaining about? I don't know if I've answered your question.
Yes, so there's been this call for a so-called national dialogue, which I suspect is going to be the next stage, and I don't know how it's going to pan out. But if there is an interesting national dialogue to be had, my view, and feel free to agree or disagree, is that constitutional reform should not be banned from that conversation, which is also not to say that we should scrap the Constitution and start from zero, because there's a lot in the Constitution that we would simply remake exactly as it is. But I do wonder whether the consensus around the Constitution, as you've mentioned, which used to be, incontrovertible is coming apart, and whether we need to have another look at the Constitution itself and say, you know what, this has worked, maybe this needs to be improved as part of a wider dialogue about policy and about identity, but not leaving the Constitution out from scrutiny. Parliament has a review mechanism, which it doesn't seem to use, which is also hilarious because everyone criticizes the Constitution and they don't submit anything to that review committee. But I get that it's also dangerous to put the Constitution up for debate again. So there's a balance to be struck. But I think let me put it this way. I think there's an interesting and possibly creative moment to rethink the Constitution. And I don't think we should dismiss that moment out of hand.
Yeah, so this is a difficult question because for me, in the sense that it should never be off limits to agitate or to argue for this or that part of the Constitution, or either small or fundamental changes to be made, because it shouldn't be a rigid document set in stone. So the difficulty is maybe, and this relates to what I said just earlier, is that it's sometimes difficult sometimes the argument for me is not actually about the Constitution as Constitution.
Yeah, sure.
It's a broader, it is fundamental disagreements about who we are, about how we live, which is not going to be solved by tweaking this section on the appointment of the president in that section. It is, and in a way, it is understandable because we haven't really reckoned with 350 years of colonialism and apartheid, and the Constitution was sort of putting a rainbow nation plaster over it all. So that is there.
Yeah.
I don't know. So framing that fundamental schism as only a constitutional issue is maybe not helpful, although it might be politically advantageous. So I understand why people do it. I'm not sure that is helpful. But it would be really interesting to hear what people's ideas are. So if there's a moment, if people come with ideas, no matter how radical they are, that is better than saying this one is bad. But we have to have something. So if there's going to be a debate, it can only really have meaningful consequences if people say, well, we think this is really bad about the Constitution. This is another option. Look, we think this will do that. It will curtail the power of white monopoly capital or whatever. It will make a difference. Then we can use the Constitution to have the fundamental debates and arguments about, about who we are, how we want to be governed, and so on. But if it's these broad brushstrokes kind of condemnations or broad brushstrokes kind of applause and kind of validation, I don't find it helpful. So I find it quite amusing that the parties in the coalition come together under the Constitution and it says we support all the provisions in the Bill of Rights. The DA signs it, but the Bill of Rights section 9.2 says there must be redress, affirmative action. That court says the race-based affirmative action is not only permitted, it's sometimes required. If the PA comes in, the Constitution says no death penalty.
It's
so people use the for and against the Constitution are often, for me, a little bit empty. It often becomes empty rhetoric from both sides.
I agree, and I think this constitutional debate can just get so heated so quickly, and there is this need to sit back and say, what are we talking about? are we talking about the Constitution as myth? Because then it's not even about the text. It's about how the text functions. And even if we change the text, the function of the text might remain the same. And I hear you in that if you're launching a critique, then which parts of the Constitution are you launching that critique against? And what is your proposal for reform? And have you thought through the unintended consequences of what such a reform might be? And that's an interesting conversation to me. I just hope we can have that conversation, and maybe we must curate it as a country somewhere, because I also worry that if we just rely on these fallback positions on the Constitution, as these parties are doing, we fail to rise to the need to reinvigorate the Constitution. And it's actually quite interesting to me how static the Constitution has been compared to other constitutions around the world. I'd like to see a bit more dynamism around,
So maybe there's something else though, because for me the critique of the Constitution that I most take most to heart is that the Constitution was born in sin. That that moment didn't reckon with the past, that it was a kind of perpetuation or confirmation of the obliteration of indigenous cultures and ontologies, whatever. I think that it's a very difficult discussion to have because people are so in their lagers. But for me, that is a valuable national dialogue.
Absolutely.
Because we are living in a country that the evidence of the past is everywhere around us. The racialized inequality, all of these things. It's impossible. And so getting a discussion, an honest discussion about that, and even if we agree or disagree with the specific arrangements in the Constitution, for me, that is really, that would be really valuable. Whether the politicians are up to having that discussions and actually engaging with one another in a meaningful, honest, robust, but in a way that people can hear, I'm not sure that is possible.
Yeah, no, that's a really fascinating perspective. To close off as well, I mean, we could have this constitutional chat for 5 hours. Stay tuned for the next one. But there are also, and the majority of the Constitution is actually the design of the state, from cooperative governance all the way until general provisions. And maybe we also haven't had a public conversation. There have been legal conversations about, the design of the state itself, because I think there's also an interesting conversation to have there about cooperative governance and its tension with separation of powers, for example, or the spheres and how they work together, or parliament and the president. So what are your thoughts on the future conversations on the Constitution as we enter a new political era, which may shed light on these more design elements?
So there's always difficult to know what is politically feasible and what one thinks should happen. For me, the fact that not only that the ANC has lost its majority in the National Assembly, it also lost its majority in the National Council of Provinces, but only when the provinces are going to decide on matters not affecting the provinces, because then each member of the NCOP, National Council of Provinces, has one vote. If the NCOP deals with matters relating that affects the provinces, they get a mandate from the provincial legislature, and the ANC controls the majority of the provincial legislatures. So this suddenly puts the NCOP on the map. They've been a bit of a sleeping beauty until now. And it also then makes us think about provinces.
Very interesting.
We have this very odd system of quasi-federal, but not at all federal system. We don't actually know what the powers of the provinces are when they share the power with national government. So my personal view is that the provinces should be abolished. But politically, it's not feasible because there's too many patronage involved.
I like how you're like, no, the constitution should stay as it is, but abolish the provinces.
No, if I'm not going to fight about it, but it doesn't seem, in principle, again, it's good to have democracy closer to the people, but in our system, the provinces haven't really worked.
And I think there's such a problem where literally people who are supposed to have power actually don't know what powers they have. So you get the structural problem, which I think is behind a lot of service delivery. I don't think it's corruption. It may well be corruption sometimes, but people just don't know what they have the power to do.
Yeah. Yes. So it's a very complicated system, which because of the hegemony of the ANC for the first 25 years of the system hasn't really been tested. The DA sort of tried, but even they haven't been as obstreperous as one would expect them to be. So it really, so we really have to think about how, if we're going to keep it, how to make it do its job better. Yes, there are, of course, other issues like electoral system. The small parties all hate me, but I think we should put a threshold, introduce a threshold, so you can only get into parliament if you at least win 1% of the vote, 2%. 18 parties in the National Assembly is too many.
I think.
For various reasons, it's not good for coherence. And there are other parts, of course, you can... for the more liberal types, of course, the JSC, too many politicians. And that's an argument.
I think it says something about opposition, the biggest opposition party. So does that mean MK comes into the JSC? Or?
This is the most fascinating thing. If the DA goes into the government, they're not opposition party, then MK becomes the official opposition.
And then they go into the JSC as well.
I'm going to watch those hearings.
Professor Pierre de Vos, thank you so much for joining us. We could talk even more about all of this, but you've given us food for thought and also informed our audience about many of the constitutional challenges ahead. Thank you for the great work that you do, and thanks for joining us on SMWX.
Thank you, and thank you for your great work.
Thanks. I'd also like to thank two companies that are part of this SMWX community who have really helped us on this Cape Town trip to bring you all the content we're going to bring you. The first company is Black Brick. They have accommodated the SMWX team and also given you this wonderful venue from which we're going to shoot some content when we're not at Parliament. So I'd really like to thank the people at Black Brick in Cape Town, but they're also in multiple places in South Africa. If you're ever looking for excellent accommodation, make sure you check out Black Brick. And I'd also like to thank the people at Lula who are helping to transport the SMWX crew as we bring you this coverage. Lula's a company that takes particularly crews and companies and workers, whether you're going to a festival or you have an off-site event where you're transporting lots of people. Lula gets you from A to B in a really seamless way. And I want to give a big shout out to Lula. Thank you for watching this channel. Thank you for continuing to build and grow this channel into an important, independent digital force in South African politics. And I think after this government is formed, we might just be that crucial counterweight, that crucial critical voice that our country very much needs. See you in the comments. Aye.